15 minutes for questions. Yes, Corey.
I have a follow-up to Jim's comments, and what I want to suggest is you offer them as a friendly amendment, and I'm wondering if they can be pushed in a way that can become more of a criticism of Professor Dworkin. In particular, I think it's a line of argument that suggests a place where Dworkin and Rawls might actually come apart. Okay, sorry. So the way the argument works, right, or the amendment to the argument works, is you suggest that Dworkin is concerned to protect rights, but there also should be a role for responsibility, and there could be a role for responsibility alongside the protection of rights. So while we protect rights, the state might, for instance, in its capacity, its expressive capacity as speaker, or perhaps through spending, promote responsibility. And the point that you made, Jim, is that in particular, notions of responsibility that are tied to an idea of equal citizenship, for instance, might be promoted. And all this, I think, is perfectly liberal and also consistent in many ways with at least Rawls' idea of liberalism. But in the web, right, that Professor Dworkin creates earlier, there's a deep notion of the ethical, too, right, in particular the notion of reflection. And one kind of question that came up earlier was whether in that web, the notion of the ethical posed a potentially a view that went more towards perfectionism and beyond liberalism. And this is a place where I think it comes out. It's clear the web is compatible with rights. It's clear that the conception of the ethical is compatible with rights, and the fact that it forms part of the web that underpins rights is there's nothing illiberal in it. But once we start to open up this other category of the state and its expressive capacities, promoting certain values, it looks like the state isn't just promoting values of equal citizenship, but also a conception of the good, and in particular, for instance, the idea of moral reflection and the idea that reflection is a good life. So I guess my question is, does this line of argument not only open up the possibility that liberal responsibility might be part of what's promoted by the state, but also a kind of perfectionist responsibility that encourages people not to just live lives consistent with equal citizenship, not to join hate groups, not to challenge the idea of equality, but also to live good lives in the sense of reflection? And that, I guess, strikes some as perfectionist rather than liberal. The state of Singapore is the extreme example. They encourage people to have more kids in the newspaper. That's not quite the vision of the ethical here, but it certainly the notion of reflection, I think, goes beyond citizenship. So could this be taken more as a kind of criticism, or a place where the view becomes more perfectionist than liberal?
Okay, excellent points or question. Well, there's no doubt that I'm interpreting Dworkin's liberalism as a more moralized liberalism than is commonly thought. I don't think it goes all the way to that kind of perfectionism. And I myself have pondered to what extent government may inculcate virtues. I tend to draw the line at thinking government may inculcate civic virtues, but not moral excellence more generally, bearing in mind that it's hard to draw that line. And you mentioned to what you alluded to Rawls's political liberalism. I think it is certainly compatible with government inculcating certain civic virtues, but obviously he wants to stop short of conceiving government's project more generally as being to inculcate moral perfection. I don't think Ronnie draws as clear a line between those two things. And you're right, I think that this book in particular on ethics might seem to, or certainly raises questions that he hasn't answered about the extent to which government may inculcate or encourage moral excellence or ethical excellence in his excellence, to use a term more compatible with his vocabulary. Oh, I want to add a footnote to Robin's paper on the rights as trumps. The first paper I ever wrote on Dworkin, right after taking rights seriously, was published when I was in graduate school. I used an epigraph from Thomas Hobbes' Leviathan, and there's a wonderful line in Leviathan where he draws an analogy between trumps in politics and trumps in card playing. And he says, in politics, when nothing else is turned up, clubs are trumps. Now he doesn't mean, now he means the clubs of the authoritarian state, presumably, but I think that clubs as trumps could bring out the harm of rights as trumps.
Thank you.
Thanks. This is also for Jim, and it follows up a little bit on Corey Brett Schneider's point. Jim, have you given any thought to the influence in this regard of introducing dignity as the ground of rights? In recent European law, and particularly law under the auspices of the European Convention on Human Rights, there's been a sort of turn to developing a pretty fiercely objective account of what rights there are, that is seeing rights not necessarily as waivable, alienable, disposable at will or whim by the people who have them. And so there's been an emphasis that the state is entitled to condemn as degrading certain things that maybe a more subjective theory of rights, to use that old vocabulary, might endorse. I mean, the clearest example of this is the French case about dwarf throwing. You know, where they have these contests where big burly men
Bowling.
pick up dwarves and see how far they can throw them in a sort of bowling alley. Okay. And the French courts held that this was degrading to the dwarves, whether they consented to the practice or not. And South African courts, using South African provisions about the dignitary basis of rights, have suggested that laws against prostitution cannot be ruled out on liberty grounds, because prostitution is an inherently degrading way for a person to earn their living and for men to obtain sexual services. And similar things have been said in Belgium about sadomasochistic practices and so on. There's been this whole sense that if dignity is treated as a ground for rights, then it becomes much easier to pursue this older objective notion of rights, which in many ways we're committed to anyway by the strong theory of inalienability, but it takes a turn that gives that particular emphasis to responsibility. And it's not just a matter of the state encouraging ethical practice by various good works, it's a matter of conceiving how the rights themselves are limited. I mean, I worry a little bit that one of the things that happens in Justice for Hedgehogs is that dignity is introduced as a massively important premise, but it's not systematically related to the other uses of dignity in the human rights industry, or there's no attempt to either relate it or distance it from other uses of dignity in the world of political and legal philosophy today. And this seems to me to be one area where we might usefully pursue some contrasts or some similarities between Dworkin's views and other dignitarian theories.
Excellent comment, and I'm going to engage in some buck passing to Ronnie to let him respond to that during the discussion. But I do think that this brings me to, I want to relate this to a point that I do make in the paper. I said that it may be underappreciated the extent to which Dworkin disavows developing what he calls a fundamental interest theory of rights. He doesn't start with a conception of the person, what's necessary for their moral development. He doesn't start with a conception of autonomy and what limits that impose, and he doesn't start with a notion of dignity. Rather, he starts with a theory about the limits on governmental action apart from any such conception.
My question is for Robin. Robin West. Robin, I wonder why you don't characterize your criticisms in a slightly different way. It seems to me that in speaking about the duties of the government, that's a very natural way a very natural turn to do to that comment is to understand the duties as being correlative to rights that you believe are urgently important and not being attended to. So one way to articulate your concerns would have been that there has tended to be too great an emphasis on negative rights than on affirmative rights. I myself don't think Dworkin is guilty of that charge, but in any event, I wonder why you're interested in eliminating or downplaying rights discourse rather than in shifting the emphasis to affirmative rights rather than in rights in a sense that disables the government from doing things?
First of all, I've pretty much written myself out on positive rights. I've got just nothing more to say on the score. But more to the point, of course, much of this can be resaid in the language of positive rights. Children have a positive right to an education that will prepare them for autonomous and independent adulthood, for example. And I'm completely sympathetic to those arguments. I think that it's whistling in the wind, and that it's whistling in the wind precisely because we don't have a strong tradition or even a strong academic tradition, but certainly not a strong public tradition in this country that focuses on the duties of lawmakers, the duties of legislators, and therefore the duties of citizenships. I mean, what's at the heart of all of this, I think, whether you cast it as affirmative rights of people to things from the government or duties of the government to do things for people, what's at the heart of our inability to mount the political will to make those things happen is a lack of fellow feeling among citizens right now, and that is a failure of citizen sovereignty. I mean, that's the basic point that I want to make. That's the reason for the shift. I mean, first of all, of course, I mean, there's plenty to be said along the lines of, well, the court's never going to grant the existence of affirmative right to anything, right? Look at DeShaney. That's true, and that's a huge problem. But even if you acknowledge, as I do, the importance of what Larry was calling yesterday under-enforced constitutional rights, of which there are many, and they are important, including an unenforced constitutional right to a government that pursues the general welfare, as well as the various phrases of the 14th Amendment. I grant the existence of under-enforced rights. I think they're extremely important for the reasons that Larry said and a number of others, but the failure of the court to recognize those rights is only the tip of the iceberg. What really matters is the failure of our governors, which is ultimately ourselves, to recognize those obligations and those rights. And so, to my mind, what's most vivid about our political culture is that lack. And I just don't think it gets articulated well through the language of positive rights. But logically, the point is absolutely sound.
Okay, unless there's any specific questions for Hugh or Ed, perhaps we'll turn it over to Professor Dworkin in the interest of trying to stay on schedule. Well,
are there any other questions? Yesterday, there was a good argument for you taking it panel by panel because we had 2 days ahead of us, 6 panels ahead of us.
okay.
But
Well,
there may be, if there are other questions, maybe we could take them since you'll have the chance to reply to both of these panels later. Does that make sense?
I've already failed in my duties as moderator. I see.
Sorry.
Okay.
Sorry.
A question for Robin. I want to pose Corey Bretschneider's question to you. What does your call for a new category of, let's say, constitutional duties imply for a perfectionist state?
And until I read Jim's paper, I hadn't thought about this in a long time. Legislative duties to inculcate virtue in people, I sort of recoil at the thought. But I do think that there are legislative duties to act in ways that promote individual interests in individual autonomy, but also individual interests, our collective interest in each of us individually living good lives. And the good there is partly a moral good, but it's also partly a material good. On the particular issue, by the way, about reproductive rights, I think that one little perfectionist move that the state could make that it hasn't made is encouraging people to feel and act on a duty to use birth control and to not have sex when either party doesn't want it. And if You know, we have virtual campaigns all over Baltimore City. There's these billboards all over the city talking about virginity and talking about how marriage works and talking about your future can wait, but sex can't, no, your sex can wait, your future can't. All this kind of stuff. It's all over the place. It's incredibly perfectionist. There's no public relations campaign anywhere that I've ever said that says sex is great if you both want it, okay? And really not so great if you don't. Whether or not I'm not talking about rape, I'm just talking about unwanted sex. If you got rid of it, you would cut way down on the abortion rate, on the rate of undesired pregnancies. And likewise, if you just had a public relations campaign for a moral duty, not a right to use contraception, but a moral duty to use contraception, you'd cut down on unwanted pregnancies. So I don't have a global response to that. I have sort of particular perfectionist projects that I wouldn't have any objection to, though.
Did I, is some-
I have the microphone. Well, my question is about Hugh's chapter, but I am not entirely sure that Hugh will want to respond to the question. So maybe Professor Dworkin will want to later. It's a simple question. When Dworkin says that law really emerges from political morality only when political institutions have reached a certain stage of development, isn't he thereby indicating that a theory of law does not purport to have a universal scope, but rather applies to practices of law in mature democracies, and so is tackling a completely different issue and has a different project than other general jurisprudential theories? Question also about the point of view taken by the theory, so insider, outsider, that's my question. Thank you.
I think that's an excellent question for Professor Dworkin. I would love to hear his answer. No, my justification for saying that is I'm not sure whether I'm taking this one remark about the importance of institutionalization in his account of law too seriously, or making too much of it, right? So I would actually be very interested in hearing what he has to say on that score.
Is that it for questions? I think we're technically out of time. So thanks to the panel. We'll have a short break and reconvene for our final panel.